All right, good afternoon, everybody. Welcome. It's 5 o'clock by my computer watch, so we'll make a slow start. I'll start with the introductions and we'll get going with the content of today's webinar. So thank you very much to all of those that are joining us. Thank you for your time and thank you for your interest and participation in this webinar and topic. To introduce the panelists this afternoon, I'd like to welcome and introduce Sicelo Kula, who's an attorney with Michalsons Attorneys, joining us from Cape Town this afternoon. And Sicelo has been our professional advisor as we've tried to develop POPIA Compliance Toolkits and training. And he's going to be leading our discussion this afternoon, which is targeted at information officers and for trustees and directors of community schemes managed by Trafalgar. So welcome, Sicelo. And thank you for partnering with us in this webinar and this POPIA compliance journey. Joining us from Cape Town is Karine Kutsia. Karine is Trafalgar's property management consultant. She's been with Trafalgar for 20 plus years, and Karine's been project managing the POPIA compliance program from a Trafalgar perspective. And then my colleague Shanith Nepal joining us from Durban this afternoon. Shanith has been project managing Trafalgar and Trafalgar Group of Companies POPIA Compliance, and Shanith will be Trafalgar's Deputy Information Officer, and I've been registered as the Trafalgar Group of Companies Information Officer, and hence my participation and interest as well. So just a few general comments. So today we're really addressing the topic of the requirement to register as an information officer for community schemes with the information regulator. The information regulator's website is now operational. It is now possible to register online, and we have already registered various community schemes information officers online and for Trafalgar as well. So that's good news. The registration is fairly simple. It's fairly quick. We have the documents out with the majority of our clients, and we will be indexing and archiving those as they come through. So hopefully there are a number of other trustees that are also part of this that would like to know about this role, and we will then talk about the roles and responsibilities and expectations for information officers based on the legislation. And then Sicelo will talk to that, as well as the toolkit that has been developed to assist buildings to be compliant. And Sicelo will go through the index of those documents and discuss a summary of what's in them, how to use them, how to apply them, and to make it as easy as possible to get them implemented. So we'd like to make this afternoon as interactive as possible. So please do feel free to ask any questions you might have under the Q&A. We extended the time a little bit longer than the normal 1 hour to provide time for questions. So they are welcome, and Sicelo is ready to answer any questions related to POPIA which have come to mind. The session will be recorded. We're very happy to provide a recording link afterwards, and to any trustees or directors that have missed. I will give contact details at the end, so you will be able to email myself, Karine, or Shanith, and we will respond to any questions we haven't covered today and also circulate the recording link. And of course, we're more than happy to answer any questions that crop up down the line. So from a Trafalgar perspective, we will be providing as much support as we can now and going forward. And, if we don't know the answers, we'll certainly consult with Sicelo and he with his colleagues so that we can get you an informed response. Can I just also, emphasize a health warning? This is new legislation in terms of being fully applicable or implementable from 1 July. So as with any new legislation, it is a moving target. What we think now or say now could change with case law or new guidelines from the information regulator or different opinions that come to the fore. So it is a moving target. So please don't be offended or worried or disconcerted if there are shifts in understanding. It's absolutely normal under the circumstances. And, as many of you saw, there was already a significant shift where we had understood initially that the managing agent could be the information officer for a community scheme. That was unfortunately overruled by the guideline from the information regulator, indicating it must be a senior executive in the community scheme or the chairman by default, and certainly somebody within the body, meaning it must be an owner, otherwise, but preferably a trustee or the chairman, and that was a guideline that was circulated. We do plan to write to the information regulator with the assistance of Michalsons to ask them to revisit that particular opinion on the basis that trustees and directors typically rotate, some on an annual basis. They work part-time, overtime, without compensation, and most of the personal information sits with the managing agent anyway. So we were more than happy to cover the role. It was unfortunately the guideline that changed that, but we will be trying to take that further and lobby differently, and we will keep you posted, and we've already spoken to Sicelo to assist us with that. So I'm going to hand over now to Sicelo, and I will try and group and present questions to Sicelo as there's an opportunity through the presentation. So Sicelo, thank you very much indeed. If I can hand over to you.
Okay, thanks, Andrew, and afternoon, everyone. And thanks once again for joining us. As you probably would have heard from the previous webinars, I love talking about data protection, so I'm going to have the time of my life right now. And yes, as Andrew said, also just feel free to ask as many questions as you can around this issue. I know that you've got many burning questions, and of course, it's quite complex, and this area of the law is quite new. And I imagine, of course, that many of you feel a bit overwhelmed. The one thing I would say at the outset is please don't panic. You would have probably seen this presentation in the previous webinars, but what I'm going to do today is I'm not going to do a repeat of what I did previously. I'm just going to instead emphasize some of the things I said previously, but more specifically, I'm going to link it to the specific tools that are in the toolkit, just to make sure that there is that connection for you. And you can see when we talk about consent, how that relates to the toolkit, for example, when we talk about the information officer, how that relates to the toolkit, when we talk about suppliers, specifically those suppliers or service providers that process personal information on your behalf, namely your operators, how that relates to the toolkit. So that'll be the approach from my side. And of course, I'm happy to also answer questions. So yeah, without any further ado, let's really jump into it. So one of the things that I really just want to emphasize, and I would have touched on this previously if you'd seen the recording, but it's just, I think, worth touching on, and that is why data protection is important. I've spoken to many trustees who asked me, why is this something that is worth even considering? And even owners in community schemes who don't even understand what this is about. And for me, the important thing that's worth saying is that it's about protecting people from harm. It's about protecting owners, visitors, tenants, contractors, people that interact with a community scheme. That community scheme will likely in one way or another process their personal information. And it's about protecting those people from harm, protecting those people from losing money because their personal information wasn't protected and was stolen by cyber criminals. And let's say their bank accounts were hacked. That's just one example that I can give. Their identities stolen, they discriminated against using their personal information. There are different types of harm that can befall a data subject, the people that interact with a community scheme. And so it's just important to emphasize that as a starting point. And then just before I leave this slide, another thing I wanted to emphasize, and I'll tell you, yesterday I was speaking to someone from a very small community scheme, about 26 units in it. And she said, why is this something that, or what do we do? What do we have to do what bigger community schemes do? Is it the same approach for all community schemes? And for me, the answer there is no, not all community schemes have to do exactly the same thing. And I'll explain that now. So ultimately, it comes down to the impact. if the impact of POPIA is low on your community scheme, meaning, for example, that you process very little personal information, you don't have many units in your community scheme, the kind of personal information that you process is, let's say, email addresses and cell phone numbers and obviously names, that and people's addresses, of course, but you don't do biometric fingerprint scans or anything like that. Maybe let's say you don't even have CCTV cameras. You can see how that, compared to a bigger community scheme that has 500 homes and does a whole lot more processing, you can see how the two are at different ends of the spectrum, and how POPIA affects the one community scheme more, meaning that the risks for failing to comply are higher for the one community scheme as opposed to the other that does very little processing. So for example, for the community scheme that has a very low impact where you do very little processing, something like this toolkit, and also just making sure that you do some of the practical things, that can actually be enough from a compliance perspective. But for the community scheme where the impact is much higher, then the toolkit and attending these webinars or watching these recordings will help you to at least maybe achieve some sort of minimum compliance, along with the protection that Trafalgar has put in place for the personal information. But there will be other things along the way that you will have to think about from a compliance perspective, as opposed to the community scheme that has low impact from a data protection perspective. So that's something that I really just wanted to emphasize as well. I've touched on it previously, but I thought, especially after I had that conversation with the lady from that small community scheme yesterday, it was worth touching on. The other thing that's also just worth touching on is, in terms of timeline for POPIA, of course, the basic thing to say here is that there's no time to lose. The grace period is coming to an end on 1 July, and meaning that the consequences for failing to comply, those will actually now become a reality. If, let's say, you experience a data breach, your community scheme experiences a data breach, and the information regulator can then take action against you for that. So that's just the one thing that's important. And in light of the toolkit, the one thing that's also worth mentioning is, use it, use the toolkit. We're going to talk about what the different tools can be used for, in what context, but the point is, use it. Don't have the tools, but then not use them. And that's really the important thing that's worth stating from a timeline perspective. And then, just very importantly, in terms of role players, again, I would have touched on this, but it's important to just know, in the universe of data protection and the different role players that are involved, where your community scheme figures, where Trafalgar is, and where other service providers are. Of course, I would have mentioned previously that your community scheme is a responsible party. In the EU, it's called the controller. You're the responsible party, meaning you decide why personal information is processed, and typically also how it's processed, but not necessarily. And of course, POPIA then applies to you and places the obligations to comply on you and your service providers. The people that process personal information on your behalf are your operators, and POPIA requires that there be a contract in place. So you'll see, if I just leave this presentation for a moment and switch across to this here. So this is one of the tools that is in the toolkit. It's called a data processing agreement. And this is really the agreement that's meant to be in place with an operator. So one thing that I've actually just been thinking about to make your lives easier is that I've actually worked out that, and I had a conversation with Andrew about this. I went back to POPIA to check this, and I'm pretty happy that actually Trafalgar can enter into this data processing agreement with the various other service providers that you deal with as a community scheme, and then you can sign the data processing agreement with Trafalgar, and you don't have to go and sign separate data processing agreements with each and every service provider who is also an operator of yours. But yes, this is what it looks like, the agreement that needs to be in place with operators, people that process personal information on behalf of the community scheme. I won't go through the whole agreement, but I think it was just worth showing what it looks like and just contextualizing it for you. And of course, if you do have any questions around that, drop that in the chat, and I will pause at various points to just take those questions. So I'll be doing a lot of flipping back and forth just to make sure that I can show you the related tool that I'm talking about. I won't go into detail around personal information and what that entails and special personal information. You can watch that recording, but the one thing that's just important for your purposes, and I'll touch on this when I get to plan, is that there's a POPIA questionnaire that we've developed, and I'll show you this later. And the idea with that questionnaire is it's supposed to just help you get a sense of what personal information you would typically process and in what context you typically process that personal information, just to get a sense of what's happening within your community scheme, because it's very difficult to obviously take action and protect personal information when you have no idea what's happening. And the important thing, of course, from a POPIA perspective, is that with certain kinds of personal information, the more sensitive kind of personal information, the impact of POPIA arises the more you process that kind of personal information. So for example, if you process health-related information or information relating to people's fingerprint scans, as opposed to just processing their email addresses and phone numbers, the impact rises. If you process account numbers or children's personal information, the impact rises. So that's something that's just worth keeping in mind. And then just in terms of the different rights that a data subject has, there are various tools that are related to this, and I'll keep coming back to these tools. So I think it's worth just flipping across just to show you. For example, a data subject has the right to know that their personal information is being processed and what personal information is being processed and why that personal information is being processed. So you can ask yourself then, well, how do we communicate this in an effective way and in a legally compliant way to the data subject? The answer there, one of the answers would be through the privacy policy. And now I know, of course, that not all community schemes have a website on which this privacy policy can live, because typically the privacy policy lives on the website of an organization or the website of a community scheme. But in my mind, and this is very much the same belief that we have at Michalsons, is that even if you don't have a website, you can still have a privacy policy, and you can then just draw people's attention to that privacy policy. For example, I don't know if I have this tool open, but there's actually a notice that you can have at the entrance into your community scheme. That notice mentions this privacy policy. And also, there's a consent form that you can use for various purposes. For example, you can get your owners to sign this consent form. You can get visitors into your community scheme to sign this consent form. Think of people that are coming to contractors, for example. And in this consent form, there is mention of the privacy policy as well, just to make sure that the two are linked. So that is certainly the one way in which you not only obtain the consent of the data subject, but you also inform them that their personal information will be processed and what that personal information will be processed for. The important thing, of course, to note about the consent form is that just because you've obtained the consent doesn't mean that the data subject can't come later and say, no, I don't want you to process my personal information anymore, in which case you then have to rely on some of the other grounds in POPIA for continuing to process their personal information, such as where there is a legal requirement, a law empowering you to process that personal information, or there's a contract basically that entitles you to process that personal information. I actually argue that because someone lives in a community scheme, that actually in one way or another empowers the community scheme to at least process some personal information, let's say to identify them as part of securing the premises of that community scheme. Andrew, are there any questions so far about what I've covered?
Sicelo, there are questions. Not necessarily exactly what you're covering. Quite a few just sort of asking why the managing agent cannot be the information officer. I think maybe we can just show on screen the guideline and exactly how it was phrased, which is why the managing agent is not currently authorized to be the information officer. Can I just ask, there were questions about, can the general manager of a community scheme or a caretaker be the information officer for that scheme?
No, it can't be, I'll put it this way, it can't be an ordinary employee or a low-level employee. It has to be someone within management, someone who has influence, who is at the executive level, basically. And you'll see this when I show the guidance note. I'll show it when I get to plan and I talk about the role of the information officer.
Okay, but assuming a general manager or an estate manager is the most senior operational role at the estate, would that be sufficiently senior to cover the information officer role?
Yes, it can be then.
Okay, and then just an important comment from somebody on the webinar, just to say they've been advised that you are not able to register as the information officer for more than one legal entity. And it's a principal officer with pension funds, and apparently they've engaged with one of your attorneys at Michalsons on that point. So I think that might be something that would need just to be investigated. Somebody did ask, can they be the information officer at work as well as for their community scheme? And I'm not sure now if there is a clash there, whether you can be registered for more than one legal entity.
Yeah, that's certainly worth thinking about, and I'm happy to think about that issue a bit more and also just chat with some of my colleagues that I usually work with when it comes specifically to the role of the information officer. I mean, it's quite tricky as well because, I mean, you obviously mentioned earlier, and maybe it's actually good to just flip across, but I did just want to emphasize the risks for failing to comply before actually touching on the role of the information officer. But I just wanted to say, though, that you did mention, of course, at the beginning that part of the way in which we're going to alleviate or address some of these issues is by actually submitting representations to the information regulator, perhaps even applying for an exemption as well, just to get some finality on these issues, because I think they're going to dangle until we actually get confirmation. I mean, I had to tell a client the other day that, look, ultimately, when it comes to POPIA, yes, Michalsons can give you an opinion on some of these issues that are in doubt, but the opinion that really matters and that gives finality is that of the information regulator.
Thank you.
Yeah.
All right, I think carry on for now, please, Sicelo.
Okay, sure. So I just wanted to, and I know that this question is one of those recurring questions, and that is, what will really happen? What are the risks for failing to comply? What are the risks for failing to register an information officer? So if we start with for example, the risk of failing, and I'll show this when I show the guidance note. The guidance note specifically mentions, for example, that if as the information officer, let's say you're the default information officer, and I'll talk about how every organization, including community schemes, have a default information officer, the head of the organization. In the context of a community scheme, that's obviously, let's say, the chairperson of the board of trustees. That person, if at any point the information regulator were to issue an enforcement notice to say community scheme X, I need you to stop processing this personal information, there's been a complaint, or I need you to provide me with a record of your processing activities. And as community scheme X, you don't comply with that enforcement notice, that actually there's criminal liability that is attached to that failure. So that's just one example of failing to comply. And then if we just talk about the community scheme itself, I mean, there are a number of potential consequences. For example, the information regulator can fine the community scheme, meaning that if there's a breach, for example, the information regulator could say, community scheme X, you have to pay 2 million for failing to protect that personal information. This is a reality. It happened in Europe. There are many examples under the GDPR of organizations being fined. I don't have examples in the EU of community schemes there being fined, but trust me when I tell you, it's not out of the realms of possibility. As far as anyone specifically going to jail, it's difficult to say, but probably unlikely that anyone will actually go to jail. It might be that even when there's some sort of criminal liability, you're ultimately then, as the person that's liable, maybe made to pay a fine. Paying damages, that's definitely a reality. Your owners, for example, could sue your community scheme. You can have other people that interact with your community scheme and whose personal information the community scheme processes, who come together and say that they will sue the community scheme. Class actions are a growing area of the law in South Africa, and there are increasingly more and more lawyers that are willing to take up the cases of clients who don't have money and will pay maybe when the case is won. So on a contingency basis. So that's definitely a reality. And not to mention, of course, the reputational damage that your community scheme can suffer. The fact that people might not want to buy units or rent units in your community scheme, and that has various implications for your community scheme. So there definitely are consequences that could befall your community scheme for failing to comply. And then just before I move away, the one thing for me that's really worth mentioning, and I did touch on this when I was talking about the impact, the potential impact of POPIA, and that is when you're looking at POPIA, and in fact, this pretty much applies to other data protection laws as well, but specifically POPIA, it's really about trying to keep it as practical as possible, trying to think about the everyday examples of when you process personal information and trying to think to yourself, okay, so we do have CCTV cameras. What can we do to minimize the potential for a data breach? How long do we keep this CCTV footage, since we have these cameras? Where is it kept? Is it in the cloud? Is it on a video cassette somewhere? I know I'm hearkening back to the 90s now, but yes, where is that footage kept? And who has access to it? Does it have to be kept for 6 months as opposed to 3 months, for example? So those are some of the practical things. And if you have paper-based personal information containing, let's say, like the registers at the entrances into community schemes, where does that information go? At the end of each day, at the end of each week, at the end of each month? Do you have to hold on to it wherever you keep it for as long as you do? Can you not shorten that period? Why are you keeping it for as long a period? So those are some of the things that are really worth thinking about when it comes to POPIA. It's really trying to look at your context, the context within which you operate, look at what's specific to your community scheme, look at what some other community schemes that are similar to yours, similar in size, for example, similar in terms of where they are located, and look at what they are doing and try to compare it to yours. Take something like the toolkit and look at how to practically apply it. So those are just some of the key things. And of course, and I touched on this earlier, it's about achieving outcomes. So it's not about just getting this toolkit and having it without actually using it. So having this privacy policy, but no one knows about it. The owners don't know about it. The tenants don't know about it. The visitors, the contractors, no one knows about this privacy policy. The consent form is not being used to actually capture explicitly the consent of the people whose personal information your community scheme processes. The data processing agreement isn't being used, and yet you have all of these suppliers that process personal information on your behalf. It's about making sure that you achieve outcomes. And of course, those outcomes vary. For example, with the privacy policy, that one of the outcomes would be to inform people, as I mentioned earlier, that their personal information is being processed, and to also specify some of the reasons for that personal information being processed. And just before I move away, awareness is also key. You'll see in the toolkit that there's a POPIA plain language guide. Now, that's a very useful document. It has two versions to it. The one version is generic and can apply to any organization. The other version is then more specific to community schemes. Have a look at that plain language guide, because it'll answer some of the everyday questions that you have around community schemes and data protection. This is what it looks like. It's a 7-pager. It's not a very hectic document. It's drafted in plain language, very easy to read. So I would encourage you to read this document in addition to watching the recordings of those other webinars that I did, and to circulate this document amongst your owners, amongst your tenants, just so that there is that buy-in about data protection, about why personal information is being processed, about what it means in practical terms.
So Clela, should I give you a break? I can just ask some of the questions and make a few comments as well.
Yes.
Just worth saying that, you know, if the demands are sufficient, there is an opportunity for a deputy information officer to be appointed and registered. So there can be some delegation of the responsibilities through a deputy. So bear that in mind, although it seems the problem we've got is finding an information officer at all. So many questions about, you know, why do the trustees have to register and they don't have any personal information, and, you know, it's not technically right or correct. But unfortunately, that's the law as it stands at the moment. Yes, we're going to lobby for a reconsideration, but it's what it is at the moment. So, you know, we will be providing as much training, as much support, the toolkit to make it easy and practical to comply, and that will mitigate the risk to a large extent. So I think just bear that in mind, that there is help and support and the necessary policies and procedures, you know, around us, which we're talking about today, which will go a very long way to achieve the necessary compliance, provide the necessary peace of mind, and safeguard against personal liability and some of the sanctions that Sicelo mentioned. I have also answered several questions that the standard insurance policies for certainly sectional title schemes do include trustee indemnity insurance. So, you know, that is in place. I will just double check the scope of cover and whether it would cover any potential risk in this area, but certainly the trustees are covered. And for homeowners associations, that would need to be checked. So the policies tend to be reasonably different. So that certainly is in place. I'd just like to mention the executive managing agent role. So for sectional title buildings, the new legislation from 2016 provided for an executive managing agent to be appointed by a special resolution. That role takes the roles and responsibilities of the trustees. So at the moment, Trafalgar, we've got about 22 executive managing agent schemes. It is growing. It's specifically for buildings where no one wants to be or has the time to be a trustee. And it's a way of outsourcing those roles and responsibilities And that executive managing agent, by virtue of assuming the roles and responsibilities of the trustees, of being the senior executive for the scheme, would be able to register as the information officer. So it is a consideration where there is anxiety about this legislation and a lack of willingness to cover that role, which unfortunately is a legislative and compliance requirement. So just to point that out to you. Sicelo is going to go on to the role expectations of the information officer, who then is accountable for compliance. So, the fact that they're accountable just means they need to make sure that the necessary policies are in place, that the necessary disclaimers are in place, that the right data processing agreements in place, and that the managing agent, that actually manages most of the personal information on behalf of the scheme, is suitably compliant and responsible as well. So being accountable doesn't mean the same thing as doing everything or being, overall in charge. It just means putting the right policies, procedures, and agreements in place, and then overseeing it as a matter of course with their executive or their fiduciary responsibility with the community scheme. So, Sicelo, do you agree with those comments? You can comment and then maybe proceed, please.
Yes, okay. So before I get into the role of the information officer, one thing I thought was just worth mentioning is relating to the governing body, and that's of course the board of trustees or board of directors in your community scheme. The one thing that's important, and this is one of the ways in which community schemes are unique, is of course that there is that rotation where in a lot of community schemes, I wouldn't necessarily say most, and I think Andrew and Karine would know more about this just from looking at the trends over the years. But from what I've seen, there is definitely rotation where you often find that not all the trustees from one year remain in the following year. And so the key challenge there is then that one board of trustees can have their awareness raised, let's say this year, because there's this activity, there are these webinars that we're doing, but then the following year or the year thereafter, another board of trustees almost feels like they're starting from scratch because they're coming in cold and they don't feel like they have any level of awareness. And yet POPIA will still be a thing. It'll still be a reality. And in fact, at that point, it'll probably be in full swing and we'll have a lot more certainty and enforcement at that point. And so the key thing for me is just to ensure continuity, to ensure that as one board of trustees, that you basically pass on the buck as the years go by and you step out, then you make sure that the people that are coming in after you have a level of awareness about POPIA and what it means for your community scheme and what's been happening, what's been put in place. And then very importantly, then the role of the information officer. This is, of course, as I said, a very important person for your community scheme, for any organization for that matter. Every organization, community scheme or otherwise, has an information officer by default. That is in terms of PAIA, the Promotion of Access to Information Act, which POPIA has then taken and said, okay, this is going to be the case as well in a data protection context. So that's then unavoidable. And it's, of course, as I said, the head of the organization. In the context of the community scheme, it's, for example, the chairperson of the board of trustees. This person has various responsibilities, both under PAIA and under POPIA, but mainly under POPIA. Under PAIA, for example, if, let's say, I was a person who wanted to request access to the information records that Community Scheme X holds, then the information officer would have to process that request of mine, regardless of whether that community scheme was exempt from having a POPIA manual or not exempt from having a POPIA manual. And you might have heard, and this is often the tricky part about the information age that we live in, is that there's so much information. There are always these alerts, and you often don't know what applies to you and what doesn't apply to you. So for example, you might have seen an alert about POPIA regulations, about the information regulator being involved with POPIA, about exemptions, and there's a lot of noise there. So just to sort of declutter some of that, the key thing that's worth knowing for your purposes is, one, a POPIA manual is basically a document that sets out what information records an organization holds and what kind of procedure they'd want someone to follow when that person wanted or requested access to the information records that that organization holds. That organization includes a community scheme. Now, the key thing is, many organizations, many private bodies have been exempt. And of course, a community scheme is a private body. Many private bodies have been exempt from having a POPIA manual. And only the private bodies that fit into a certain criteria are not exempt. For example, if your community scheme happened to have 50 employees, which is unlikely, happened to have a turnover of about 15 million per year, for example, then you'd have to have a POPIA manual. And your information officer would then be responsible for compiling that POPIA manual and complying with some of the other responsibilities or obligations that are set out in POPIA. So that's something that I thought was just worth mentioning under POPIA. And then under POPIA, there are many responsibilities that an information officer has, and I will show you in a moment the information officer appointment letter. That is a very good template or tool to use to formally appoint your information officer, along with the board resolution that your board can pass, just to make sure that everyone is on the same page about the appointment, the formal appointment of the information officer. But at a high level, as you'll see here with this list, the key thing is really that the information officer is responsible for helping your community scheme to comply. That means, this is where it becomes so important to draw the different connections. For example, earlier I spoke about the rights that a data subject has. The information officer is there to make sure that the organization, that the community scheme gives effect to those rights. So the information officer has to ensure that these tools that are in the toolkit are actually being used, has to ensure that the privacy policy is customized for your community scheme and is actually being circulated and is being used, has to ensure that that consent form, where appropriate, is being used, that suppliers are signing that data processing agreement. So those are some of the key things that have to happen. And of course, very importantly, wherever the personal information goes to live, whether it's the managing agent that's responsible for it, whether some of the information resides with the security company that guards your gates, and that maybe looks after your CCTV cameras, the information officer has to work with that service provider to ensure that there is a reasonable level of security that is being applied in relating to that or to that personal information. So for example, if encryption software is necessary, if that service provider needs to encrypt that information, then that needs to happen. The information officer needs to have those conversations, needs to check that the contract that's in place places that obligation on the service provider to use encryption or some of the latest technologies that are out there to protect digital personal information. And then, of course, we've spoken about in some ways, we've spoken about who that person is, and we've already established that, of course, the chairperson or the head of the community scheme is by default that person. And we've spoken about how we will, in the I don't know, maybe the coming weeks, lobby the information regulator to say, can't it be the managing agent? Because as things stand, and I will show the guidance note in a moment, it can't be the managing agent. It can't be Trafalgar that is the information officer, deputy information officer, or information officer. Importantly, though, if, let's say, for example, and I touched on this earlier, if in your community scheme, you happened to have an employee who is at the level where they are part of the decision-making in the community scheme, and they do have quite a good knowledge of the community scheme, they are reasonably tech savvy, and they have good communication skills. They don't have to have a law degree, by the way, and they don't have to have the best knowledge of data protection. They can learn as long as they have the capacity to learn about data protection. That person would also be suitable to appoint as the information officer or as the deputy information officer. So say, for example, that you, as this default information officer, you go ahead and register and you decide that, you know what, you are going to go ahead and act as the information officer, but you want to appoint a deputy, then this kind of criteria, what I've mentioned now, would then apply as far as that person that you are going to appoint. And as far as the structure is concerned, you can really decide how many deputies is appropriate for your community scheme. I imagine that things are going to change depending on what the information regulator says community schemes are allowed or are not allowed to do as far as the appointment of the information officer. But for now, you basically can have as many deputy information officers as you like. So for example, each trustee can be a deputy information officer. You could have up to 4 or 5 deputy information officers. There's really no limit. It's about sharing the load. The key thing that's also worth mentioning is, let's say, for example, that we lobby the information regulator and they take forever to respond, or they say, no, it still can't be Trafalgar that will be your information officer or deputy information officer. It doesn't mean that there's no possible way of sort of going around it. And by going around it, I don't mean that you can appoint Trafalgar as the information officer behind the information regulator's back. I just mean that you can have this one person that is registered as the information officer, but the actual day-to-day responsibilities that come with being an information officer can then be delegated to Trafalgar. And of course, that conversation you could have with Trafalgar, but I'm just putting it out there that that's also a possibility as well. And it would obviously be worth having in writing just to make sure that everyone is certain and on the same page about what that delegation actually entails. But that is a possibility as well. And then importantly, the appointment has to be in writing. And the information regulator has given out some forms that can be used, but has said that it is okay as well if, as an organization, you use a different template to do the appointment, to effect the appointment. And one other way of having it in writing is, of course, to pass a board resolution. I'll just flip across now to show what these look like. So this is what the information officer appointment letter or letter of appointment looks like. And of course, this template you can use for both the designated information officer and the deputy information officers as well. You can see that it sets out various things around the appointment, when the appointment is, but more importantly, it sets out a list of the duties and responsibilities as well. You'll see many of the ones that I mentioned earlier, like compiling the access to information manual, meaning the POPIA manual, processing requests, and also then under POPIA, some of the specific ones. I won't go through the whole document. You can have a look at it once you receive a copy, but it was just to really show you what this appointment letter looks like. This is then the resolution that gets passed by the board to appoint the information officer. Now, this is not a POPIA requirement, so you're not actually required to pass the resolution, but just for the sake of certainty, especially because there is this rotation of trustees, I think it would be quite handy to have a resolution so that when the next board of trustees or next batch of trustees comes along, there is this resolution that they can refer to that points them to this appointment to say, hey, look, this is something that is a reality for our community scheme. This is what it was in the past. Let's reevaluate, let's reassess and see where we are. Andrew and I have at various points mentioned the importance of registering the information officer. And that's, of course, a requirement that is in POPIA, and it's also something that is spelled out in the guidance note as well. And this is something that's, of course, unavoidable. In fact, POPIA goes so far as to say the information officer can't actually take up their duties until they've been registered with the information regulator. The reason there really is that because the information regulator relies on an information officer to know what's happening within a particular organization, they need to have access to that information officer. They need to have the details to know who that information officer is, whether it's the default information officer or the designated information officer or the deputy information officer. The registration has to happen. And as Andrew said, when you go to the portal, when you go to the website of the information regulator, you'll see that the portal is up and there's actually a tab up here when on the website that you can click on to access the portal.
So Sikela, there were, just won't you pause there, there were several questions about what the website address is for the information regulator, which you've just shown there on your screen. So maybe you could just bring it up again, and those that were wondering where to find the information regulator site, that was it. So it's there, it's justice.gov.za/inforeg. So
Yes.
there it is. And then
Yeah,
I believe from my colleague Sikelo that it's fairly quick and simple to register online. So it's not difficult. It doesn't take long. It does work. He's done it. So, you know, where there are changes to trustees or directors, if the existing information officer should sell or not be re-elected, then a new information officer would need to be registered in the same way that Sikelo explained.
Yes, unless we
Yeah,
somehow...
just to add, sorry, just to add there, for our complexes that we manage, we are doing this. We are registering, so the trustees don't have to worry about registering information officers. We are doing it for them. And yes, it's very quick and easy to do.
Yes. And yeah, our managing director actually did it for our firm. John Giles did it the other day, and I saw that he got some sort of certificate as well after he did it, just to confirm the registration. But yes, this is what it looks like, the portal itself. And I'm glad it's finally up. And of course, in here, you can see the countdown, the dreaded countdown about the POPIA deadline. That's the information regulator's way of I suppose, threatening organizations to say, I'm going to come after you. Actually, let me switch across to the actual guidance note. So this is the guidance note that the information regulator issued on the 1st of April. And as Andrew was saying, we thought things were a certain way, and then this guidance note came out and basically shifted the way we understand many things in relation to the role of the information officer, specifically around the issue of outsourcing. So I'm just going to go to the areas that I highlighted specifically. It's, as you can see, it's 29 pages, so we'd be here for a few hours at least if I had to try and go through each aspect of it. I think for me, one of the key things that was worth highlighting, and I've already mentioned this, is of course that in the context of a private body, this person or their equivalent is the default information officer. So this is what that question related to earlier about subsidiaries in a group of companies. But that's something that's still not the clearest. And then just another key thing that is mentioned here in the guidance note is that when the default information officer delegates to a deputy information officer, for example, or designates someone else as the information officer, they retain the ultimate accountability for what happens regarding the role of the information officer. So that's something that's also just worth mentioning and worth thinking about, is that even though it is open to the default information officer to designate someone else, and of course for the deputy information officer to be appointed, it doesn't mean that you then stop thinking about this issue entirely. You still have to have some level of involvement, and that's why having the appointment in writing is so important as well, because it then means that you retain some level of control over how this person that you delegated to is going to carry out those responsibilities and act as the deputy or the designated information officer. You can see here at 5.8, it's mentioned that the authorization must be in writing. Again, what I was mentioning about how it doesn't necessarily have to be the template that the information regulator issued. It can be something that's substantially similar. We believe the template that we drafted at Michalsons, which is part of the toolkit, is such a template that's substantially similar, if not better, than the one that the information regulator provided. And then very importantly, what we've been talking about around who can be the information officer. Two things here. Any person authorized as information officer should be at an executive level or equivalent position. And then this means that only an employee of a private body at a level of management and above should be considered for authorization as an information officer. The key thing that's worth mentioning for community schemes, and this is why it would be so useful to approach the information regulator, is that trustees technically aren't the employees of a community scheme, but they are still internal to the community scheme and are exercising authority over the community scheme, are at an executive level. So for me, that's very much the case, that you can appoint one of your trustees as the designated information officer, or someone that is actually an employee employed by the community scheme. Yeah, so let me switch back to the presentation. I mentioned earlier that the information officer doesn't have to be an expert in data protection at the time that they are appointed. In fact, we actually had to change the wording in the information officer appointment letter that's part of the toolkit, because obviously the concern that anyone being appointed within a community scheme as the information officer would have is, wait, do I have to be an expert? Do I have to have a law degree? But we had to just change that wording to say that the appointment is basically being made on the basis that this person that's being appointed is intimately involved with the community scheme. They're at a decision-making level in the community scheme, and they can learn. They have the capacity to learn about data protection, to undergo training. And the training comes in different forms. It comes in the form of webinars like this. It comes in the form of the Michalsons Data Protection Program, for example. There's a lens in there called Training for Information Officers. So it comes in different forms. And eventually, when we get to that point, currently it's not possible to get certification for your training, but we will eventually get to a point when maybe you can undergo certain training and get certified. I know currently in the program, there is an assessment that an information officer can complete to test their level of awareness when it comes to data protection and their role as the information officer. So those are some of the things that are involved as part of training and increasing your knowledge of data protection, which you don't necessarily need to have at the time you're appointed as the information officer. Yeah, Andrew, are there any questions?
There are a number, sort of quite repetitive on the themes that we've talked about. I've actually typed answers to 71 questions so far.
Yes.
I think at the end I'm going to ask Karine just to recap on, exactly what is Trafalgar's approach in terms of the next steps to make the toolkit available. What is the index of that toolkit? What exact next steps and actions are envisaged, which will be supported by our portfolio manager team. So we'll get to that, summary and conclusion, I think, after your presentation. There's also been a number of questions about private CCTV cameras that many owners have on their own homes, and whether that does constitute, capturing and recording personal information, and how the owners and the schemes would need to safeguard those images. So, I think at some point you are going to talk about, those considerations: CCTV cameras, personal and scheme biometric systems, as well as, other personal information that might be captured in registers. And COVID registers are a topical item as well. So maybe you could just bring in those comments as you go, Sikleto.
Yeah. So the other thing that I actually wanted to touch on, and it is related to this, is often when I do a presentation like this, under plan, when I talk about planning, an organization planning its compliance, I typically talk about mapping of activities, which involves looking in detail at the activities of an organization to try and get a sense of what activities involve the processing of personal information. Now, I'm very aware, keenly aware, that because of time constraints, for example, it isn't really possible to do a detailed mapping of activities exercise where, as the information officer of a community scheme, you go through each and every exercise and you look at things in great detail, and you compile this record or ROPA of processing activities, which of course is required ultimately in terms of POPIA. But I think a shortcut just to get something, as opposed to not having anything at all, just to get something in place, what I've done is to put together what I decided to call a POPIA questionnaire, and I'll just flip across to that. And I mentioned this briefly earlier. So this is what the document looks like. And the idea with this document is that it asks some of the everyday questions. It tells you here at the beginning how it works, but very importantly, it asks some of the key practical questions around what your community scheme is actually doing, what some of its activities are, what kind of personal information it typically processes, and in what context it processes that personal information. And this obviously helps and informs that practical approach to protecting personal information, because if you haven't really sat down and thought about it, then you won't really know what some of the practical realities are in your community scheme. For example, many community schemes don't have the issue of owners having CCTV cameras on their properties, as opposed to the scheme having CCTV cameras in the common areas of the community scheme. And so then naturally the question arises, well, how do you deal with something like that? And so again, the answers aren't always straightforward. So for example, with something like that, think about what your rules say. So your conduct rules in your community scheme. Have you had, even just informally, a conversation with that owner to find out what happens with that footage? Where are those cameras pointed? Are they just pointed inside the yard? Because it could very well be that they're not actually capturing the neighboring areas or the neighboring properties. So it's to have some of those conversations, and then importantly, to then get into some enforcement mechanism as well, just to force that owner to manage those cameras in a certain way, because it's very understandable why someone would want to have cameras. But let's talk about the management of that. Let's talk about them, essentially the same kind of approach that a community scheme would take with its own CCTV cameras in the common areas. Those kind of considerations apply there as well with the owner, because you don't want the footage being kept for unnecessarily long periods. You want it being deleted. You want the cameras pointing where they should for the sake of the security that the person is trying to enforce, and not pointing at the neighboring properties when it doesn't need to. But it's very difficult to give straightforward answers when it comes to this, because it differs from community scheme to community scheme, and there are unique sets of circumstances with each, so it varies. It's not always easy to give blanket answers that everyone can take and run with. But if we just get back to this POPIA questionnaire, you'll see, for example, that it asks about your website, because one of the practical realities is if your community scheme has a website, it would be very important for something like the privacy policy to live on the website. So I'll just switch across to show you the Michalsons website, where we have something called a trust center. And I'm not saying that your community scheme containing 26 units needs to now go and have a whole website with the trust center, but you can imagine that some of the community schemes that are bigger, that can afford something like this, it would be worth looking into, to have the policies live on your website, the ones that relate to your owners, that relate to members of the public, that interact with your community scheme, to say, We are trying to be transparent to build trust with you whenever we process your personal information or wherever we have a relationship with you. These are some of the terms that apply to that relationship. Here is our privacy policy that sets out how we process your personal information. Here is a cookie policy that sets out the cookies that are used on this website, and specifically those cookies that involve the processing of your personal information. Here's a security policy that sets out how we typically safeguard your personal information. You can even have something like the POPIA Plain Language Guide be on a website, on a page like this. And then there are other practical considerations like wanting to know whether your community scheme has a WhatsApp group and what it uses that WhatsApp group for, because not all WhatsApp groups are equal. Some WhatsApp groups are actually necessary as part of the operations of a particular community scheme, where others, you can easily see why it's very voluntary to be part of that WhatsApp group, because it won't actually affect the running of the community scheme if someone is not a member of that WhatsApp group. But for others, for example, in order to receive municipal services, there it becomes a different scenario. I know that some owners might actually push back on this idea of them being added to a particular WhatsApp group. But as I say, it varies depending on the purpose of the WhatsApp group. And so you'll see some of the practical questions here. Do you always ask for consent before adding data subjects to a WhatsApp group? Data subjects being someone like an owner, for example. Who is the administrator of the WhatsApp group? Do you even have a WhatsApp group? And then there are questions related to your processing activities. Just asking, for example, do you have employees? Because naturally that also involves an extra level of processing as well, because you pay salaries, you have to let them in and out of the premises. And then do you have CCTV cameras? Who processes the footage? Is it a managing agent? Is in conjunction with a security company? Where does that footage go and live? Is it in the cloud? What cloud platform is it?
Sicelo, just an important point we actually haven't emphasized too much today, but there actually is legislation which does prescribe that personal information may be made available or shared. So, for example, in sectional title schemes, the sectional title legislation does provide for any owner to request personal information. And one example would be to call a special general meeting. So where there are legal prescripts in other legislation, that does authorize personal information being shared and made available. So POPIA can't be considered in isolation. It is one of several, legalities that need to be considered. And these would be things that the information officer would need to be guided on, so that they're aware when personal information may be shared and made available and when not, and what are valid reasons and what are not. So just to make that point that, there are cases where, personal information must be made available both by the managing agent in consultation with trustees.
Yes, definitely. I mean, this is related to the issue, for example, of consent forms. The fact that if someone is refusing to sign a consent form and they're refusing to provide certain personal information, and there is this legislation that applies to your community scheme and entitles your community scheme, at least as far as its operations are concerned, to process personal information in relation to those operations, then yes, that can be a justification. Obviously, the important thing to mention there, again, and when you watch the recordings of the other webinars, you'll definitely see this point, and that is that if, let's say, this piece of legislation says for the purposes of running your day-to-day operations of collecting levies, you you can process personal information, it doesn't mean that you can process any personal information. Let's say any personal information that you have access to. You can only process the personal information that is related to the particular purpose that the legislation empowers you. So you can only process personal information in relation to the collection of levies, for example. You can't now process people's HIV status or people's biometric fingerprint scans just as part of collecting levies if that's not actually connected.
Thank you.
And are there any other questions?
There are quite a few, but they're on the same themes that I think we have covered. You know, lots of concern about CCTV cameras, which I think we've touched on. You know, also what to do when no one will be willing to be the information officer. I think we've touched on that as well.
Yeah, because from my side, and I know you mentioned earlier that Karine was also going to just say a few things. I'm happy for her to just come in now, because I think from my side, I've pretty much gone through all of them, the tools that I wanted to touch on in relation to this presentation.
Perfect. All right, so thank you for that, Sikleto. So Karine, may I ask you to come in now, and perhaps you could just talk to, you know, what exactly are the next steps now to take the toolkit forward, to customize and apply it correctly? What will our portfolio managers be doing to support and assist that? And, you know, practically now, what needs to happen before the 1st of July to basically get this done?
Thanks, Andrew. Okay, so basically, practically, what we've done is we've put together, with the help of Sicelo and Michalsons, a toolkit. There is the index of the toolkit. Sicelo touched on some of the documents in the toolkit, but the idea is not that we just dump the toolkit and all the templates on our complexes. We are taking you through them, through the whole index one by one document at a time. So we've started basically with the first two a while back, where we are asking our trustees and directors to pass a resolution, which we've sent the template for, in order to appoint an information officer. And also we've sent the information officer appointment letter. We had to make some changes to that subsequently because of the guidance note that came out from the information regulator, and a couple of other things, but your portfolio manager has the latest template for that. What we are currently busy with is to register all the complexes where the information officers have already been appointed. We are currently busy registering them with the information regulator. And as Andrew said, we get a certificate for that. So we can send, and the person that we register as information officer also gets an email from the system with that certificate. But Trafalgar has that certificate as well, and we are keeping that as part of the body corporate or homeowners association document library. And then the next step that we're currently busy with is the checklist for community schemes, or as Sicelo called it, the POPIA questionnaire. So we're basically busy completing that together with our information officers. We're getting together all the details because, as Sicelo also mentioned, a small scheme with 5 units that only collect levies from people and have the bare minimum of personal information stored will obviously have different things that have to be put in place than a huge estate with 500 units and community and CCTV cameras and websites and all of that. So we are, first of all, we're doing this checklist or questionnaire that Sicelo showed you. The next step that we will be looking into next week is the POPIA privacy policy for community schemes. So each community scheme is supposed to have a privacy policy that Sicelo also showed. So that will be the next step, is just to customize that for our community schemes. And again, the portfolio managers will be working on that. It is just a little bit of customization that needs to be added to that. It covers all aspects. and also in terms of the questionnaire that we are completing. What we will be doing next then as well is the data processing agreement that Sicelo mentioned and showed you, to get that signed first of all with Trafalgar, between Trafalgar and the community scheme, because Trafalgar basically processes most of the information on behalf of the community scheme. So we definitely need to have that in place with Trafalgar. And then we're also looking into getting that in place between the community scheme and the other operators. So basically your auditor, your insurance broker, the collections attorneys, people like that. So we are working on that as a next step. We've got the clause for HOAs. As Andrew mentioned, in terms of the Sectional Title Schemes Management Act, there's already the provision to be able to collect personal information, and we must collect the personal information in terms of the Act, and also sometimes share that information. But the HOAs do not have something like that in place. So what we are proposing, and from Michalson's side, is a clause that can be included in the HOA, either in the Memorandum of Incorporation if it's a company, or in the Constitution if it's a voluntary or common law association. There's also a privacy policy notice board that we got the wording from Michalsons that we will assist our complexes in order to get to the notice board. It's like a disclaimer to be put up at your entrance. We will be working on that as well. And then Sicelo mentioned the POPIA plain language guide. So that was already sent out to all our portfolio manager teams to share that with the trustees and directors and information officers and owners if they want. It is basically plain language that answers a lot of the questions. And then the last step that will need to be done before the end of June will be a circular that will be sent to all owners. As Sicelo said, it doesn't help you do all this work and you have everything in place, but your owners do not know about this. So we will be sending a circular as a last step then to all owners with that will include the complex's POPIA privacy policy, specifically for that community scheme. It will also include a consent form for if there is information at that specific scheme that is not covered by the sectional title legislation. For example, the sectional title legislation covers that the body corporate must keep the owner's contact details and the tenant's contact details, but it doesn't cover, like Sicelo said, it doesn't cover biometric. It doesn't cover if you have an access system where you have to put in your fingerprint, or if you have CCTV footage. Things like that, that is not covered by the Sectional Title Schemes Management Act, so that we need specific consent from the owners. So that consent form will be included in that circular, and we will also include in that circular, again to all our owners, personal particulars form, just to make sure that we get all the correct information, because it's not just keeping the information, it's also ensuring that the information that is on record is correct and up to date and relevant. So that will be included in that as well. And all of this basically needs to be done before the end of June. So yeah, as I said, don't expect to get an email with the whole toolkit and we just dump it on you. We are going to work through it. We already started working through it with our complexes. But yeah, as we said, the first step being the appointment of an information officer.
All right, thanks, Karine. So, yeah, I think we're working through this. We do need to make sure our portfolio managers are engaging with the trustees and directors to work through this. It might make sense to have a meeting during the course of July to work through it and get it done. We have developed the toolkit and the templates to require minimal customization, so there's not a lot to do. General awareness is important. It would be important for the designated information officer to, read the policy documentation, to have a good working knowledge of what's in there, and obviously ourselves and Michalsons on the background for any questions or queries which do crop up. Sicelo, I was hoping you would just refer to or show everyone where your frequently asked questions are on the Michalsons website. I think that's another very useful resource which can be available for everybody. So have a look there if something comes to mind. Most of the questions are recurring themes, and there's a lot of anxiety coming through the questions, which is quite natural. This is new legislation. It's fairly onerous responsibilities and onerous penalties. This is a volunteer role we're talking about, so it's understandable that there's anxiety and a degree of aggravation. But I think if we work together and we methodically go through and apply the toolkit, it does go a long way to mitigating those risks, to getting the necessary safeguards and compliances in place. And going back to the heading of the legislation, it is protection of personal information, and we are just trying to put suitable and practical safeguards in place to make that happen. So I think Sicelo is just demonstrating for us exactly where the frequently asked questions are. So you would just search in their search field, and there we go. Sicelo can just quickly show that.
I think we're likely going to actually put it as a link in the footer of our website eventually, but for now, you actually have to just search in the search bar, search FAQ. But another quick way to get to it, because the FAQs, and here they are, so you should just have to click on this. Another quick way of getting to them is I've linked to them in the POPIA plain language guide as well. So in reading that, because the two are quite closely connected, and in fact, this plain language guide does have a mini FAQ section as well. And you'll see that it does link through to our website, through to the FAQ section on our website. And that FAQ section is constantly being updated as well. So there are two ways for you to get to it, either by clicking on the link here in this POPIA plain language guide, or going to our website and searching for FAQs. But you'll find probably in the coming weeks that we're going to link to it in the footer of our website, just to make it that much easier to find.
Okay, thanks very much, Sicelo. Karine, can you maybe just quickly comment on, what we will be providing to owners in schemes? So we've talked a lot about the information officer, what trustees and directors need to be aware of, but what will come to the owners in schemes, and where will we place that sort of material?
Andrew, as I said, the last step of our toolkit is to send a circular to all owners to inform them of the complexes or the community schemes privacy policy, and also to just make sure that we've got the correct information for them. But what we will also do is on our website, we will also have a page with regards to POPIA, where will we, for instance, be able to put the plain language guide, put a link to Michalsons' website, put a link to Michalsons' website's frequently asked questions. So yeah, we are working on that as well.
So the consent form is part of the toolkit, is it not, Karine?
Yes, it is, Andrew.
Yeah, okay. Look, and then part of the role of the information officer as well is to oversee the compliance policies and procedures, to investigate any data breaches and to address those gaps, and obviously to develop and improve the policies, etc. So, as I said at the beginning, as we get further guidelines from the information regulator, as there's case law, as there's guidance provided by specialist advisors like Michalsons and Sicelo, there might well be an opportunity to add to or supplement or extend certain of the policies, etc. But, I do believe that keeping it simple, keeping it practical, and, just making a solid start, as we're recommending with the toolkit, will be a responsible, initiation for the information officers and this particular legislation. Sicelo, can I ask for your closing comments, and then Karine and Shanith, and then we'll close on that basis.
Yes, thanks, Andrew. I definitely second what you've just said now. And for me, ultimately, so if I just flip back across to this, I basically repeat what I said earlier, which is that for smaller community schemes where you process very little personal information, something like this toolkit, and then just entrusting the personal information to Trafalgar and the different systems that Trafalgar is using to protect the personal information could actually be enough. And it'll just be a case of checking in every now and again to make sure that each new trustee is using and knows about the toolkit and is still using it. And then for the bigger community schemes where there's more processing and the impact is higher, then it involves a bit more. Then something like this toolkit is basically an interim measure just to make sure that when the deadline comes around, you're not starting from square one, that there are certain things that you've at least done, and that should anything happen like a data breach, where you then have to be, in terms of POPIA, where you'd have to inform the information regulator, for example, and they come and they want to audit what you've been doing, you can at least show that, look, we have been trying. We did try and put some minimum things in place. But of course, what the information regulator would then tell you, based on the impact of POPIA on your specific community scheme, is the impact on yours is high as opposed to others. So there should be other things that you should do. For example, I mentioned the mapping of activities exercise, where yes, in the interim, you can use the POPIA questionnaire just to get started. But let's say in September, for example, where now at least you've gone past the deadline, then maybe you can revisit this and start to do a more detailed exercise. But ultimately, data protection is a journey. It's an ongoing journey. It's something that you have to keep looking at and thinking about. Even when the impact is quite low right now, it doesn't mean you never have to think about it ever again. You do have to occasionally revisit it. And so that's why that continuity is so important between the different trustees that come along in the lifespan of a community scheme.
Thank you, Sicelo. Karine, any closing comments?
Yeah, not really much from my side, and I think we've said it all. If there's any questions or anybody wants the link to this webinar, you can email me. There's my email address, Andrew's email address, and Shanice's email address. So you're welcome to email us if you have any questions. But yes, as I said, your portfolio manager is equipped and will be equipped even more to take you through the process. Thanks, Andrew.
All right, thank you. Shanice, in closing, can you just give a quick 1-minute summary of what, as Trafalgar, we are doing and busy finalizing to safeguard the personal information that we are processing, and which is important in terms of peace of mind for the information officers and in terms of the data processing agreement that we will sign up with the complexes that we are managing?
Thank you, Andrew, and good evening, everyone. I must say thank you to Sicelo as well. It's been a very informative webinar. From Trafalgar's perspective, we've taken various different measures to ensure that your personal information is safeguarded. So one of the first steps we've done is to firstly get an information governance committee in place to ensure that we have the right governance structures in place to manage compliance with the Act. And we have various other technical and organizational measures which we've undertaken. We have various policies that are currently being drafted, which will be made available on our website. And we have various different security measures over our systems that will give added protection to information that's processed by us. We're also currently busy with training our employees. There's national training initiatives being undertaken. So from a POPIA compliance perspective, you can be rest assured that all reasonable measures are being taken to ensure that your personal information will be safeguarded. If there is anything you'd like to know, you're welcome to email any of us and we'll be happy to address your queries. Thank you.
All right, so in closing, many thanks to everyone that's participated. Thank you for your time. Thanks for joining us. I've tried to answer many questions. I haven't quite got to all of them, but there you'll see our contact details on the screen. We are available, we're ready and willing to help. We do have Sicelo available to assist us if we need clarity or expert advice. So, you know, there's no charge for the advice, for the feedback, for answering questions, for the toolkit. We are trying to help our schemes that we manage get this done as quickly and easily and free of charge. And it's a bit of a journey, but I do think that over the next 6 weeks, we can get it done. And then it will be a continuous improvement exercise from there. So good evening, everyone. Thanks once again. Thank you to Sicelo, Karine, and Shanith. And we will be in touch with the toolkit and the plain language guides that we've spoken about. So thank you very much indeed.